So we have some major developments in a brand new ruling involving the NFA's restrictions. A new 3-judge panel out of the 5th Circuit Court of Appeals has just issued a massive ruling that completely shifts the legal landscape surrounding suppressors and the Second Amendment. In a brand new ruling by the 5th Circuit Court of Appeals, they found and ruled that suppressors are in fact protected arms under the plain text of the Second Amendment. However, there is a massive catch. Even though the individual here won those constitutional arguments surrounding the Second Amendment, the defendant still lost the challenge because the panel was completely trapped by a prior ruling that was issued by the 5th Circuit, which in my opinion got the Second Amendment analysis wrong. However, even in this case, you had 2 of the judges on that panel issue a strong concurrence calling for an emergency en banc review to completely overturn that prior precedent, which they were bound by, and to tear it down and actually rule in favor of this individual. So let's break down what happened in this case, how this ties directly into another critical case that we've talked about, US versus Peterson, and why the NFA may now officially be on thin ice. Now, before we jump into this video, if you want to support the channel and you like this type of content, make sure you like, comment, subscribe, and turn on all notifications to ensure that you get this type of information when I release it. Now, to understand how critical this ruling is, we have to look back at a prior ruling and prior precedent in a case that we've covered in the past called US versus Peterson. That was a major suppressor challenge to the NFA. It was bringing in Second Amendment arguments under Bruin, and again, we've covered this on the channel. In that case, law enforcement officers raided Mr. Peterson's home, found an unregistered suppressor, and the DOJ hit him with a standalone NFA violation that carried a 24-month prison sentence. Peterson challenged the NFA under the Supreme Court's Bruin framework in the Second Amendment, and in that case, the 5th Circuit did something very interesting, but also something really dangerous. In that ruling, the 5th Circuit claimed that the NFA is presumptively lawful because it operates like a shall issue licensing system, and they argued that that is permissible under Bruin in one of its footnotes. Essentially, the panel's ruling established a rule saying that as long as the government has an objective process to register and tax you, that restriction can survive. Peterson then appealed that up to the Supreme Court, but recently the Supreme Court denied emergency review to that case. Because of that inaction by the Supreme Court and that prior ruling of the 5th Circuit, Peterson's final request to modify his sentence to just home confinement was denied, and I believe last month he had to report to federal prison where he currently is. So his case became a tragic real-world example of how this operates and how the federal government and their view of the NFA is actually locking people up. So that brings us directly to yesterday's brand new decision in the case US versus Camo. The individual here was prosecuted under the exact same federal statute for possessing an unregistered silencer under the NFA. He argued that the NFA violated his constitutional rights, but the district court flatly rejected that claim, and they found and claimed that silencers are dangerous and unusual weapons, not protected by the Second Amendment at all. He then appealed up to the 5th Circuit, and this new panel just did something unprecedented. The court explicitly ruled that suppressors absolutely are protected by the Second Amendment as protected arms. Writing for the court, Judge Jerry Smith dismantled the government's arguments surrounding that these were not protected arms. So the government wanted to say that these are not protected arms, but the 5th Circuit said yes, they are. The court recognized that suppressors reduce loudness, lower the risk of hearing loss, eliminate muzzle blast, and increase accuracy. The court ruled that these are critical functions that make a firearm safer and more effective for the core lawful purpose of self-defense. Under Bruin, an item does not have to be strictly necessary for a gun to actually function. Instead, it just has to facilitate armed self-defense. So this was a massive constitutional win on this specific issue. You finally have a circuit court saying expressly that yes, suppressors are protected arms. The 5th Circuit has officially cemented into law that silencers are protected by the Second Amendment, and this also creates a direct circuit split on this issue since the 9th Circuit recently ruled that suppressors are not protected arms. This circuit split could also tee up a potential Supreme Court case down the road because you have a split opinion in different circuit courts on whether suppressors are protected arms. But if suppressors are protected arms, why was this individual here still convicted, and why was that conviction affirmed by the 5th Circuit? Well, this is where the frustrating reality of the judicial system really kicks in. Under a legal doctrine known as the rule of orderliness, a 3-judge panel of the appellate court is completely bound by decisions of prior panels in the same circuit, because the previous panel in Peterson manufactured a rule saying that the NFA's registration scheme is presumptively lawful unless you can prove exorbitant fees or lengthy wait times. This new panel's hands were really just tied. The individual here did not explicitly challenge that the ATF put the application process to abusive ends, so under the Peterson precedent, his challenge was forced to fail at step 1. The judges openly admitted that because Peterson controls this circuit court, they had no choice but to uphold the conviction. But here's where this case kind of takes an interesting turn and really just signals maybe that things are going to change. The circuit judge here, Edith Brown Clement, was joined by one of the other judges, Cal Duncan. So 2 out of the 3 judges on this panel wrote a concurrence and issued a fiery opinion aimed directly at doing away with that Peterson precedent. They wrote separately to state bluntly that Peterson was a massive mistake that needs to be revisited and overturned by the full en banc panel court in the Fifth Circuit. She pointed out in this concurrence that Peterson took a random, modest footnote from the Supreme Court's Bruin decision and twisted it into a binding legal doctrine. By creating a presumption that shall issue registration systems are automatically legal, Peterson kind of flipped the Bruin ruling and analysis completely on its head and resurrected the interest balancing approach, which also the Supreme Court expressly rejected in Bruin. So think about what this means. 2 out of the 3 judges on this panel just officially put out kind of a bat signal to the entire Fifth Circuit Court of Appeals, calling for the full bench in the Fifth Circuit to grant en banc panel review potentially in this case and eliminate the Peterson ruling because they believe that the Fifth Circuit got this wrong. So what can this mean going forward? Well, it means that the battle over the NFA is far from over, and in fact, it maybe just got even more interesting. No doubt Mr. Comeau's legal team is almost certainly going to file a petition for en banc panel rehearing in this case because 2 influential judges have already written kind of a roadmap detailing exactly why that current circuit court law and precedent is unconstitutional, and there is the possibility that the full Fifth Circuit Court of Appeals will now take this case up. If this goes en banc, that court is not bound by the rule of orderliness. They can completely throw out the Peterson rationale. They can just throw it in the trash, and they can completely kind of just redo the framework, look at this purely based on the Second Amendment and not lean on Bruin's footnote and do this weird, interesting balancing that they did in Peterson. And if they strike down the Peterson framework, the federal government will finally be forced to face a true Bruin 2-step analysis for the NFA, and they will have to try to justify these suppressor restrictions based on history and tradition. Also, a full court rehearing and a positive ruling in that case would no doubt help Mr. Peterson, who's currently in prison because of this incorrect ruling. But regardless, this new ruling by the Fifth Circuit also created a critical circuit split on whether suppressors are in fact protected arms by the Second Amendment. That circuit split can be pointed to if this case, or maybe the California suppressor case, eventually makes its way to the Supreme Court. We have one court that has officially acknowledged that suppressors are in fact protected arms, and the clock is now ticking on this bad precedent that was issued by the Fifth Circuit, and it's likely going to be revisited and relooked at by the full en banc panel if one is requested. So what do you think? Will the full Fifth Circuit actually step in and override their Peterson ruling that they just recently issued? Or will they just continue to say that, yes, suppressors are protected arms, but the NFA operates like a shall issue system? Under Bruin, they believe that shall issue registration and all of this is permissible, and therefore they'll just keep the NFA in place. So let me know your thoughts down below. If you like this video and you would like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. Also, turn on all notifications, click that notification icon to ensure that you get updates and videos when I release them. But as always, thank you guys so much for all of your support. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.